Продовжуємо засідання.
Let's continue our meeting.
Прошу запросити до зали засідання.
Please invite a candidate for the position of the judge of the High Anti-Corruption Court, Tanasevych Olena Vitaliivna.
Доброго дня.
Good afternoon.
Розглядається питання щодо відповідності
We are considering the issue of compliance of candidate for the position of the judge of the High Anti-Corruption Court, Tanasevych Olena Vitaliivna, with the criteria envisioned by Part 4 of Article 8 of the Law of Ukraine on the High Anti-Corruption Court. We have present members of the PCIe, Robert Heimbrugheisen, Chair, Mary K. Butler, remotely, Norman As, remotely, Gabriela Yodkaita Granskiene, Jessica Lott Thompson, and John J. O'Sullivan. Members of the HQCJ, Ярослав Дух, Роман Кадисюк, Надія Капецька, Олег Колюш, Ігор Кушнір, Руслан Мельник, Олексій Омелян, Андрій Пасічник, Галина Шевчук. You have the right to request recusal, submit motions, challenge decisions of the Commission within the framework visioned by the law. Do you have any recusal requests? Hello, everyone. I do not have any recusal requests. Thank you. The co-rapporteur on this is Kobetska Nadia Romanivna. Please, the floor is yours. Thank you. Brief information about the candidate. The candidate for the position of the judge of the High Anti-Corruption Court, in particular of the Appellate Chamber of the High Anti-Corruption Court. Tanasevych Olena Vitaliivna, in 2003, graduated from Kharkiv State Pedagogical University of Grigory Skovoroda and got the diploma of the specialist under the specialty of legal sciences. In 2012, Tanasevych graduated from National University Law Academy of Yaroslav Mudry and got the master's diploma. In 2018, Olena defended her dissertation under the specialty of labor law, social protection law, and accordingly, she was awarded with the academic degree of the candidate of legal sciences. With respect to professional experience of the candidate, I would like to say the following. Starting from 2002 until 2010, she worked as the lawyer in different companies. On May 17 of 2010, she was appointed to the position of the assistant of the Chief Justice, and then she became the assistant judge in Kharkiv Court of Appeal, where she worked until the 5th of June of 2012. With the decree of the President of 2012, she was appointed to the position of judge of Pechenivsky District Court of Kharkiv Oblast for the term of 5 years. Since June 6 of 2012 until May 3rd of 2019, she worked at the position of the judge of that court of Kharkiv region. She was elected to administrative positions like the deputy president of the court of Pechenivsky District Court of Kharkiv region. On May 17 of 2017, Tanasevych Olena had her 5-year term of the judge expiring. She passed qualification evaluation within the framework of the competition for vacant positions of judges of the High Anti-Corruption Court, and she was recognized as confirming her capacity to administer justice pursuant to results of recommendations with the decree of the President of 2019. She was appointed to the position of the judge of the High Anti-Corruption Court, where she has administered justice until nowadays. On May 7 of 2019, Olena was elected to the position of the Chief Justice of the High Anti-Corruption Court. Powers of this court were performed until May 6 of 2022. That is within the period of 3 years. for which she was elected. She has submitted the Declaration of Family Ties, Integrity Declaration, Declaration of the person authorized to perform functions of the state and local self-governance bodies. The Commission has sent requests to public and other authorities, got information from the registers. All of that is available in the electronic dossier of the candidate, to which the candidate already has access. That's it from my side.
Дякую.
Thank you.
Пане Роберте, вам слово.
Mr. Robert, the floor is yours.
Thank you, Chairman. Good afternoon. My name is Robert Broekhuizen, and I'm also your rapporteur. So I'm going to start with asking you some questions, if you are okay with that. And the first question I would like to ask you is that we received, let's say, information from civil society organizations about you, and they mention concerns regarding some kind of an attendance of a party. And they also say, and we have read that there are articles about that, what happened at that moment. And what we also have seen, that there was a formal answer from you about this party. And I understand that what happened at this party made that you had to step down as head of the court. And I would request you to, let's say, tell us in your own words the sequence of events, because, of course, this is something which is quite widely documented. You have given answers to that. And of course, because this is open to public, it's to us to address the issue. And I would suggest that you just tell us the sequence in events, and then you begin with the beginning. How did you get to the university? I understand that the university or its director has quite a reputation also related to corruption issues. So how did you get there? How did you get to the party? What happened then? Who did you meet? Who you didn't meet? And what happened afterwards? That you tell the whole story. Is that okay?
Hello. Of course, I don't mind against answering this question. I'm ready to provide exhaustive explanations. Probably I should start from saying that information is a bit inaccurate that you've provided, because the situation regarding which I will provide explanations has not impacted my administrative functions. I have served as the Chief Justice of the High Anti-Corruption Court for the full term, and I resigned from this position after the expiration of this 3-year term for which I was elected. At the position of the Chief Justice of the Court, I attended lots of events, including events at universities. I got meetings with rectors, vice-rectors, heads of faculty, and I consider the academic environment to be quite safe for myself, because academics have no relation to the administration of justice. That's exclusively the matters of law. When I got an invitation from the rector of Kyiv Institute on Intellectual Property, it did not cause any concerns for me, because it was about actually organization of online lectures for students of this higher educational institution. There was ongoing quarantine because of the COVID-19 pandemics. Students were studying remotely, and that was a usual practice for judges of the High Anti-Corruption Court to take part in events like that. I came on a date and time agreed by us outside of working hours, and I came to this university. I entered the office of the rector. He met me. We went into the office. We discussed those issues that were necessary for the organization of these events, topics that would be interesting for students. I was asking about the year of the students so that we could accordingly prepare the reports, and so the judges could prepare lectures in view of the level of knowledge, education of these students. After the discussion of all of the moments related to that, Mr. Rector mentioned that right now, in the premises of the higher educational institution, there was a celebratory event dedicated to the New Year Eve, that they had the academic legal community, and that some of my colleagues were present, and he asked whether I would be willing to honor the event with my presence. Again, at the position of the Chief Justice, I took part in celebratory events as well. And I attended, upon invitations of embassies, similar events. In particular, with respect to the Independence Day of specific countries, or dedicated to the arrival or departure of some ambassadors. If I had time and if I got invitations, then I attended these events in order to honor in such a way these institutions. Somehow, I did not even think that I should be confused or concerned about that. And I said that I have a child at home, but then my child was 12 years old, that he was at home on his own, and that I had about 15-20 minutes, and then I would have to leave. We went downstairs where this event was held. I would not call it a party. I think that it's important, after all, to use respective terms. In my personal understanding, a party is something fun. I would even say very fun. Nothing similar was happening there. There were just representatives of the legal profession who were talking among themselves and who were congratulating each other on the occasion of the New Year. But upon entering the room, I saw that at that event there were two persons who were going to become suspects. Why was I aware of that? Because the pre-trial investigative body and the prosecutor's office were widely covering the criminal proceeding in which these two persons were involved. And there were all the time some videos, publications, posts in the media. There were provided materials of the pre-trial investigation for the public. So I was basically aware of what is happening in that proceeding, just like the entire country. When I identified the presence of these two persons, I, for myself, being aware of the need to comply with the rules of ethical conduct, I realized for myself that I could not talk to these people at all. I had to avoid communication. For fairness, I would like to point out that they were not trying to talk to me either. I saw some familiar faces. I said hello. We talked, probably I cannot even recall the topics that we were discussing, but that was something absolutely neutral. And as I planned, after 20 minutes, maybe 30 minutes, I left this event. I did not violate any provisions of the law. I did not violate any provisions of the Code of Judicial Ethics. And basically, upon leaving this event, I decided for myself that, thanks God, everything happened in such a way that no one talked to me and I did not talk to any of them. And I thought that the situation was over. About a month after that, I was very surprised when there appeared a journalist investigation regarding the fact that I was present at this event. Basically, despite the fact that I was morally ready, that I was under constant public monitoring because of my status as a national public actor. But this situation was difficult for me because this was the first situation like that in my life. And frankly speaking, that's the only situation like that as of now. So there was published this journalist investigation in which they reached negative connotations with some assumptions which could harm my reputation. Of course, these news was reposted by other news outlets, and within a week there started appearing publications of separate persons, including public activists and representatives of some civil society organizations, saying that this situation took place and that it caused concerns. Unfortunately, no civil society organization, no individual addressed the HCG with a disciplinary complaint against me. And the High Council of Justice is the only constitutional body in Ukraine which is authorized to reach conclusions whether my actions contain signs of a disciplinary offense. This way, it happened that in the media space, there was some information boom, which was undermining me, and I had no opportunity to prove that I was not guilty following the proper procedure. And then, since I care what the society is talking about me, I live in this society, my family lives in this society. Since I care about my reputation, because I have dedicated many years to having a reputation of a professional judge with integrity, and I had to undertake the unprecedented measure in the judiciary. I agreed to have a talk with the representative of the civil society organization of the anti-corruption direction, that was Transparency International Ukraine. This conversation was supposed to take place live, with a live broadcast, so that without any questions, so that any question asked to me cannot be reworded, reformulated, so that I would have a chance to answer this question. So that was a live stream. Before this meeting, the head of the civil society organization suggested on their Facebook page to ask their questions. He mentioned that he was going to meet with the Chief Justice of the High Anti-Corruption Court, and he suggested to the public to ask all the questions they wanted to ask. We had this stream. It lasted for about an hour, even though we did not plan to have such a long conversation, but I answered all the questions without ignoring any of them. I was very sincere in my answers. Maybe that was not the format that would be necessary in such a situation, because some media experts told me later on that I dedicated too much attention to that I should have ignored something. But this situation was for me so principled that I do not regret my decision. And I think that back then I acted correctly.
2-1. Shall I continue? Wait a second, please. The broadcast is back? Yeah. So yes, please continue. Let's continue the session. So I'm confident that I did the right thing because in 2-3 days, then this information wave was actually down to zero. And this story was no more reflected in mass media and no more covered in mass media afterwards. And I monitored the situation in the media space. And also would like to add that no single judge of the HCC has no complaints regarding me on potential intervention in the administration of justice, neither on the pre-trial investigation, nor on the its stage of the court litigation in this case. And also I would like to add the automatic distribution system assigned this case in such a way that I was one of the judges in the panel. So at that moment, the accused persons submitted a recusal application for me, and also mentioning regarding the conflict of interest regarding me, answering the question during the trial investigation, what is my private interest that could become an obstacle for me to be impartial and independent and fulfilling my duties. The panel of judges didn't receive any answers, and the recusal application was left without consideration. And also I would like to add that within that criminal proceeding, the prosecutor has reached out with more than 50 complaints against so many different subjects, and all those complaints were left without consideration and were returned back to complainants. And at the end, maybe it's worth adding that, yeah, I have some what to improve, but from another perspective, I also have some things to be proud of, but I definitely don't have anything to be ashamed of. Thank you.
Thank you for that. If I understand you correctly, you say that you went to this do, not a party, incidentally. So it was not, you were not invited before, but you were invited only when you went to the university. Is that correct? Yes. I understand that the head of this university is a Mr. Kivalov. I don't know him or his reputation, but I know that there is some connection between, or there are, let's say, allegations of corruption around him. Is that correct?
So the head of the Kiev Institute of Intellectual Property is Mr. Vasil Felik. That's the dean of this university. And Mr. Kivalov, whom you have mentioned, as far as I know, he is the president of the Odessa National Legal Academy, a branch, and the Kiev Institute of Intellectual Property is actually the branch of this Odessa Legal Academy. And regarding those corruption scandals, I will kindly ask you not to insist on my replies regarding this part, because I don't know whether there are any criminal proceedings regarding this person, and I don't know, I don't have any information regarding whether there are any verdicts on regarding this person. At least I don't have this information, and as far as I know, there are no. But I met with the head of the Kiev Institute of Intellectual Property, Mr. Felik.
Okay, just to understand correctly, in my translation it says intellectual property, while I understood from the documents that it was about a lecture of criminal law. What was it? Was it IP law or is it criminal law? What you were invited to do or discussed in the university?
So the name, the title of this institute just reflects the specialization. So in this institute, students get general legal education under the specialization law. So they study all kinds of law, but have specific specialization. So the lectures which actually took place, there were 5 or 6 lectures, were related to the criminal law and criminal process.
That I understand, and the translation was not correctly. And then I also understand that there was this do, and present were Mr. Vovk and Mr. Tupitsky. Mr. Vovk, of course, we all know, and Mr. Tupitsky maybe as well. Can you imagine that the fact that you were there to be seen in this room with those 2 people stirred, let's say, unrest with civil society, or don't you understand that?
I understood it when I got into the room. I took all necessary measures in order not to cause such wave. But unfortunately, to my deep regret, I can't change the past. The situation that happened, it already happened. So yeah, as much as I could, I tried to correct the situation. I tried to be open, to be frank with society. Also to add, some people are afraid of transparency and openness. Some people think that it's, too much of a burden in terms of giving additional burden to private personal life. But I am in contradiction. I think that the situation which happened at that day on 23rd of December, it could be solved and helped with transparency. And that's what I tried to show.
Thank you about it, but you do understand, I guess, that the press made an issue of this because you were the head of the anti-corruption court, and then you're in the room with those people. People get upset about it. It's understandable, no?
Yeah, of course, of course.
Thank you. I'm going to another subject with you, if you don't mind. We asked you some questions, written questions. Let me see where they are. And we asked you, let me see, about your declarations. And the first question I have, what we have seen is that you made quite some mistake in your declarations. And at a certain moment you corrected those, but still the mistakes were made. Can you reflect on that, and also on the fact that you are the head of a anti-corruption court and should be the person to file correct declarations?
Do you mean declarations that have passed a full review of the NACP?
Yes.
It's quite easy to answer your question. The anti-corruption legislation has numerous blanket provisions. It refers a subject of declaration to different types of legislation: family law, tax law, civil law, and, for example, National Agency on Corruption Prevention interprets the right of ownership and the term honor in the context of titular owner. So it means that if an ownership is registered for a certain object on one of the couples, the NACP thinks that the owner shall be declared or that person of the or that person from the couple who is registered at. So, but the legislation says that if the family code says to us that if property is procured or owned during the marriage period, then it's owned by the couple, by the marriage couple. So I guided myself by the family code provisions when I filled in declarations. So I mentioned that the land plots registered at my husband, they owned by us as a couple. The apartment which is registered at me when is owned by us as a couple. But the NACP mentioned that for the purpose of anti-corruption legislation, we shall mention this information specifically in the term as of the registered owner. And such information actually is not regulated by the law on corruption prevention. No, it's envisaged in the official recommendations of the NACP. For me, I'm guided by the law. So if the law says to me that I need to provide trustworthy information, it was obvious for me that I need to provide information about the factual status of things, of affairs. It was one of the concerns raised regarding my declarations, and there was another concern. As in my family, we have quite a few such objects. That's why I had quite a few concerns regarding it. There was also concern regarding an apartment located in Kharkiv, and which I owned, and I made a mistake regarding some small parts, like I don't know how to explain it. Part of the fact that, to fill in a declaration in our country, it's quite a hard thing to do. Unfortunately, declarations do not automatically take and extract information from state registers. You need to do it manually, fill in manually all cadastre numbers, land plot cadastre numbers, and so on. And I do it by myself with my own hands because that's my personal responsibility. And when you fill in your declaration, very often this process is just disrupted because you are disconnected from the NACP website from time to time. And it means that if you have not saved before the version of your declaration that already filled in, you need to restart the process from the beginning. And sometimes it takes a few days to submit the declaration. I try to do it during night because then the servers of the NACP are not so overloaded. Of course, I don't have any intention to conceal my property. Specifically, this information is open. It exists in all public registers, so there's no sense for me to hide this information.
No, I'm sure it's not. But what we do see is that you indeed have a lot of assets, and that when we look at the declarations, that there are mistakes that combining with the fact that you are a Hague judge and a former, say, head of the Hague, that raises concern with us. You understand that?
I can't agree completely with you regarding the mistakes. It's about the complexity and difficultness to interpret the law. But indeed, I understand your questions, your concerns. That's why I'm here, to provide you with some explanations.
We asked you about the value of 4 cars. You recall that? We asked you questions. And we asked you about the value of 4 cars. Which cars were owned by you and your husband in the period 2015-2023. And when we asked you about the value of this car, you answered, let me look at it. The law does not oblige the declarant to obtain an expert, and it also says that you have no obligation to explain the value to us. Do I understand that correctly? It's 9.3. The law of Ukraine on the prevention of corruption does not contain a requirement for the obligation of the declarant to be aware of the value of the property. And then when we asked about the value of those cars, you didn't answer the question. Why did you not answer our question? Because we are, let's say, this is not a court. We are just having a job interview. And I think the law provides that if we ask you something, you give an answer to us. So why didn't you give an answer?
Розпочну із того,
I will start with
що
the following.
конкретно у запитанні 9.2
And specifically, at the question 9.2, there was regarding the usage of vehicles. It's not about ownership right, but about the right to use those vehicles.
It's question 9.3 I'm talking about.
Так,
What is the cost? What is the value of those cars we asked?
так,
Yes.
так. Саме
Yes,
так.
Yes.
Йдеться про автомобілі, які
Here we are talking about vehicles that are owned by a legal entity, the owner of which is my husband. This is the property that is owned by a legal entity. So that's depersonalized. So my family has no relation to expenses made by the legal entity to buy these vehicles. That is the property of the legal entity. My husband is not responsible under commitments of the legal entity, and the legal entity does not have any responsibility under commitments of my husband. These vehicles were purchased for the use official use by the company. They were bought, and I know that according to my husband, he just told me and explained that they were purchased as used vehicles. Employees, including my husband, were driving these vehicles. And the National Agency on Corruption Prevention explained it as follows. Basically, I could have not declared the vehicles that have the status of official company's vehicles if my husband had not used some specific vehicle during free from work time. But since my husband, since this is business and all of his days are working days, on Saturday and Sunday he has some business trips, but also the family can be in the same vehicle when he is driving there. So, having read the explanations of the NACP, I reached a conclusion for myself that it would be better for me to declare the right to use these vehicles. At the same time, if we are talking about the inaccuracy of some information entered in the declaration, then the case law and the NACP have the approach that when you declare the right to use an object, then inaccurate information should be calculated based on the right of use and not on the value of such vehicle.
But that's not what I asked. I asked to you that we as PCIe asked you questions, yes, and you didn't answer those questions. And the reason that we asked those questions is that, and of course you know something about corruption, that we know that it's very easy to hide assets in a company, and then defending or saying that you have no obligation to declare assets of the company while you use those assets. If that is true, and let's say, then it is very simple for anybody to put its assets in a company and make sure that no one knows about it. And you are applying for a position of hak judge. And we asked you this question, and then we get a formal answer. And I see that you didn't want to answer our question. I find that difficult.
Але я задекларувала це майно.
But I declared that property. I was not concealing it. I declared it. Having read the law, having read the official explanations of the NACP, where it is directly stipulated that if the document that is given the right to use does not specify the value of the vehicle, then the declarant should choose the mark unknown. And that's what I did. If the honorable international experts want to find out the value of these vehicles, I know that according to my husband, but I cannot confirm that with documents.
we know that at a certain moment you obtained a loan from 200,000 hryvnia. That's correct, huh? And we also know that there's a power of attorney in your name granting the right of 2 cars. One is a Kia and the other one is a Mini Cooper. And then we ask you about the sources of funds of your father to pay for those cars. And do you remember what you answered to this question?
Yes, I answered that my father has his own savings and that in the understanding of the anti-corruption legislation, he is not my family member. Since I have lived separately from my parents for a long period of time.
Okay. But then we see income coming to you. We see it comes from your father. You're an anti-corruption specialist. Now we ask you as PCIE to provide us an explanation. And then you say, I have no obligation. Yeah, I find that difficult. Don't you see that it has some difficulty in it?
Не зовсім так.
Not really so. Let me form the position regarding this question. First of all, I addressed my father with a question. Where can I get and whether he has any documents confirming his assets? He said that in Kharkiv, where my parents were supposed to live but do not live now because it is very close to the border with the Russian Federation, that in Kharkiv there are documents of the executive proceeding regarding collection in funds from 2 persons to his benefit. I asked my sister to go to my parents' house and to look through my dad's documents so that maybe she could find the documents. She found one of the rulings. There were 2 rulings, but she found one ruling dated 2016 about collection to the benefit of my father according to the decision of court of 30,322 hryvnias. Back then it was about $20,000 as of 2016 in the equivalent. There is another ruling to the another amount, but my sister could not find it. If the HQCJ and PCAE don't mind, I would like to ask to attach these documents to my materials. I did not have it as of the moment of giving my answers by Wednesday. That is by the date that you established as the deadline. That's about the source of origin of funds of my father. That is the document I have.
You have to provide documents 3 days in advance of the interview. We also noted that there were 4 cars of yourself, of you and your husband. And we also noted that you didn't declare the value of those cars. What about that?
Так, я просто за регламентом громадської ради
According to the ROP of the PCIE, and you know this ROP better than me, but there is an option of submitting documents during the special joint meeting, and that's why I have this motion about providing this document about my father. Now, with respect to 4 vehicles owned by my husband, probably that's question 15.1. As of 2015-2016, the anti-corruption legislation was not as it is today in Ukraine. One of the cars from the list was owned by my father, by my husband, since 2005. We had not even been married back then. All the other vehicles were bought after our marriage, but the previous format of the declaration did not require specification of the value of these vehicles. And as of the moment of me filling in the declaration, I and my husband did not have information about the value of this property. We addressed the respective authorized body where the state registration of these vehicles took place. We got information only about the list of these vehicles. But again, this list does not contain value of these vehicles. The NACP sets out that if you do not know the value, do not conduct the CASPER evaluation, just choose this mark unknown. But all of these vehicles are very far from luxury vehicles. These are working cars bought by my husband. Unfortunately, when he was buying them, there was no requirement about the preservation of documents. That's why I thought that while fulfilling the provision of the law and while complying with official explanations of the NACP, I was sufficiently covering matters regarding the property of my family. Moreover, I would also like to point out that in 2018, I already underwent the procedure of the check of compliance with professional ethics and integrity. Some of the questions that are being asked right now by the PCIe were already the subject matter of discussion, and I gave my answers to them back then. Frankly speaking, I have nothing to add. I can only inform the value that my husband told me about, but I do not have documents to confirm that. I'm afraid that I can right now put myself into a trap because I have nothing to confirm that with. But all of my property, absolutely all of my property is declared. If you look at my declaration, then everything that I and my husband are buying, we are registering that in our name. We are not registering that in the name of our relatives, no. I have a completely transparent and open declaration for the public.
Well, we ask you to provide an explanation. You ask a question to you. How you covered your living expenses in 2015 and 2018. You recall the question? What was your answer?
Так.
What was your answer?
У 2015 році.
In 2015, yes. The question was the following. That year, we paid the credit for an apartment in Kharkiv in the amount of 900,000 hryvnias. And during the arithmetic calculation of income and expenses of my family back then, there were rising doubts about the capacity of my family to cover our basic living expenses.
That we calculated how much you had coming in and how much money you spent. And then we asked you, how were you able to live that year, 2015 and 2018? What was your answer to the question? I can read it to you if you want. I believe that you said something and then I have to look it up.
Я можу зазначити,
I
що я
can
відповіла.
say that what I answered.
Це запитання, воно...
That's the question. Sorry?
Це запитання стосувалося 2 років, 2015.
That question was about 2 years, 2015 and 2018. In 2015, I explained that that was the year of recrediting. Back then, the dollar currency exchange rate increased abruptly, and from 5 hryvnias, it became 12 hryvnias per dollar, then 17 hryvnias. Since our mortgage credit was in dollars, we addressed the bank.
What you said was, I just quote your line.
Я...
My family's monthly expenses were within the limits of our income. That's what you said when we asked the question.
Я надала пояснення, звідки...
I provided the explanation about the sort of origin of the 900,000 hryvnias, that it was recrediting. We took the credit in hryvnias and we repaid the credit in dollars. So we still had the debt remaining to the bank. We just closed the credit in dollars and we took a credit in hryvnias and we continued repaying it until 2020. And the expenses of my family were within our income. That's the only answer that I can have.
And 2018.
Yes, and in 2018, according to my calculations, the answer is the same, frankly speaking, that's the same every year. But according to my calculations, back then we had more.
You didn't provide any, let's say, explanation about 2018 at all. We asked for it. There was no explanation. You said it's just in the limits. Yeah. The point is that we asked many questions and we feel a bit that we got half answers. We didn't get full answers. And we would expect from a judge from the HACC that a HAC judge would provide full and clear and substantive answers with documents, and not an answer which would say, we had money enough. That's what you said. Well, we are here, of course, to see whether this is all in order.
Я направду надала абсолютно всі
Frankly speaking,
документи,
I have provided all the documents that I had. I have some other documents that I would kindly ask you to accept today, which I collected after the deadline for the submission of these documents, because 2 working days was not enough for me to answer this number of questions. In 2018, we did not have any expenses that could not be explained with our income. In the question asked by the PCIe, you did not ask me to provide calculations. How can I provide the calculation of how much was spent on a monthly basis in 2018? I just do not remember that. That was a couple of years ago. But after all, I would like to come back to saying that I've already answered all of these questions. They were the subject matter of the check. I have provided lots of documents. I got those documents from the archive for this period until 2018 inclusive. And that was within the framework of the competition for the position of the High Anti-Corruption Court in 2018. Right now, I do not have these documents which I provided back then. I cannot make up something. In my opinion, that would be completely unworthy. I am giving the answers as it is in the reality, as it was in the reality.
I think I'm nearly out of time. I have one question, Chair, if you don't mind. And that's about the construction in Kharkiv. You had a land plot in Kharkiv, that's correct. And we understand that the construction didn't start because you start working in Kiev. Is that correct? There was a land plot and it developed as maybe a fence around it. That's it. Can you tell me what the land plot is used for?
Yes, of course, I can tell you. We lived in Kharkiv on a permanent basis, so we intended to construct a private house. We found a land plot and we bought it. After that, we registered technical documentation. We had a design of the future house. And then I was appointed to the position in Kiev, and the construction of the house as such did not start. But we put a fence on that land plot, we put a gate, and besides there is a private solar station registered in my husband's name. That object is right now functioning.
We have seen that there's a solar station, but I don't think that this has been declared, the solar station, or the income. Is there no income from the solar station?
Of course, there is. It's declared. In each declaration, income of my husband, including income from Kharkiv Energo, is declared in every declaration. It's taxed, declared, and it's available in all the certificates and statements from the State Inspection Service.
So this solar thing on this piece of land and your husband's, it's owned. A piece of land by both of you, but it is his solar thing, yes, and the income comes to him and not to you. That's what. Do I understand it correctly?
Yes, that's a household solar station. It's allowed to install it on private land plot, and that's the type of the business that my husband is engaged into. He is building solar power stations. He is building systems of uninterrupted power supply. He is importing the solar panels, modules. He has external economic activities, etc. So yes, this solar power station is registered in my husband's name, and that's his income that's taxed and declared in every declaration.
Okay. Well, thank you. That's my last question. I'm just looking at my colleagues. Back to you.
Thank you. Колеги, я хотів би уточнити один,
Colleagues, I would like to follow up on one procedural moment. Madam Olena, as far as I understand, you've submitted a motion on submission of additional documents which you did not provide to the PCE and the HPCJ. According to the ROP, and I would like to draw attention of the members of the PCE to that, at this stage, we can accept new documents in exceptional cases if, first of all, there is a motion from the candidate and by means of a separate voting regarding this moment, whether we accept or no. At the same time, the decision has been taken if the majority has voted for it, including at least 3 members of the PCIe. So, being governed by these provisions of the ROP, I suggest to consider this procedural aspect now, so that we would clearly understand whether we are accepting new documents or no. No objections? No other suggestions?
Please, over to you. So, what would you like to prove when you want to submit those documents? In order to prove savings of my father as of 2016, this is the regulation on termination of enforcement actions that shall be terminated because of implementation of the court decision on collecting of the debt and the amount or as a relevant amount. Thank you. Dear colleagues, so what shall we do? Shall we move to the closed part of deliberations to consider this issue? Then let's move to the closed part of deliberations. I kindly ask you to wait for a few moments.
May I ask a question? Of course, of course. Yeah. But why were the documents not provided timely?
Because they were in Kharkiv. And my parents right now live in Kiev. So that house right now is not allocated for residential accommodation. All documents were left there in Kharkiv. My parents were relocating without taking documents. I asked my sister to go there to look for documents. So my sister came to that house, searching everywhere, looking for those documents. And the only thing that she managed to find that's this document. So on 12th of February, on Thursday, she managed to give this document to me as it was important. That's why I kindly asked to attach this document, this regulation to my files. I didn't have that document with me. As of 11th February, I didn't have it with me when I submitted documents to the PCIe.
How soon after the request did you ask your sister to try to obtain the document?
Yes, I asked my sister as soon as I got request.
Thank you.
Are there any other questions? Tell me, when did you receive a request from the PCIe and what was the period for you to provide relevant explanations and documents? I received a request at evening on Friday. It was on 6th of February, and I needed to provide a reply by Wednesday, by 11th of February 2026. Thank you. Dear colleagues, are there any other questions? Dear PCIe members, do you have any additional questions regarding this specific part, procedural part? Shall we consider it? Okay, then let's go to closed deliberations regarding consideration of the motion of the candidate. Can I leave my things here or shall I take it with me? It's better to take it with you, and please wait us
Запис включили? Є?
Do we have the video recording? Yes. So the Commission has considered the motion of the candidate, and the decision was made unanimously by the Commission members and the PCIA members to satisfy the motion and to attach documents to the files of the candidate. Maybe I give a floor to our rapporteur, Madam Nadia. Please, if there are any questions. Yeah. Maybe I have a question to follow up what has already been considered, and specifically regarding this part or this event in the Kyiv Institute of Intellectual Property. You responded to it at that moment, I mean, and there was also some response from the High Anti-Corruption Court on the page of the HACC. The post was made regarding that media coverage, and it was mentioned also that the HACC judges regularly participate in different learning activities and provide lectures in different higher education facilities. Regarding this cooperation with different facilities, maybe we didn't have enough time, and we didn't get a reply from you. So when you were Chief Justice of the court, maybe you remember with which higher educational facilities some kind of memorandums of understanding or any other official contracts were concluded? What was the participation of judges of the HCC within such cooperation framework? Maybe you remember the number of such events which took place, because you have just mentioned, and based on the results of a discussion with the head of this institute, some lectures were provided. How many lectures were provided? Who provided such lectures from the side of the HCC? How regularly those lectures took place? So, yes, thank you for the question. And the head of the apparatus of the court has informed me that the Qualification Commission had sent a request to our apparatus, and he told me that they were preparing information in reply, and I'm sorry to hear that you didn't get a reply. So now I can inform you of the following regarding this Kyiv Institute of Intellectual Property. Maybe 5 or 6 lectures were provided on anti-corruption topic, both regarding criminal code and criminal procedural code. Both I and other judges contributed to such lectures, other judges of our court. And what I definitely remember during my tenure, I also attended Yaroslav Mudry National Legal University in Kharkiv, and I visited it repeatedly for many times. I also visited Catholic University in Lviv, and of course, I visited Grigory Skovoroды Pedagogical National University, where I studied when I was a student. And I also visited the Kyiv National University named after Taras Shevchenko. I had meetings with students. They also visited our court with such learning visits, and I visited them to provide relevant lectures. And there were many, numerous such events, not 1 or 2, but dozens of them. And such events were carried out also with engagement of our judges, of our court. And even I will allow myself to say that during the whole period of functioning of our court, there were hundreds of such events, because our judges are so eager to meet students and participate in such events. I'm sorry that there is no official information from the apparatus of our court. But on our FB page, on our Facebook page, if you look at archives of our different events and stories, all such events are covered, some posts about it. So if you would like to find this information, you can search and find it. So thank you. Indeed, it's indeed regular cooperation, and it covered not only a single one-off event, but many events in the area of legal education. Another question, and it was also mentioned in different requests of CSOs, and you provided us with a reply because it correlates with questions that we asked you. This is a question regarding notification on intervention in the Ministry of Justice back in 2021, the decision was made by the High Council of Justice on taking measures to ensure independence of judges. And it was about the following, that you, as the head of the court, you have received a motion from MP Mr. Kamenchuk to take a preventive measure and consider an issue of application of preventive measure in the format of detention, freezing of assets and property and so on. And as it was a motion received from a member of parliament, you needed to inform about the reply. And that's why the High Council of Justice made a conclusion that in such a way, member of parliament acted beyond their mandate, and it could be considered as a legal attempt to influence on judicial authority. And the High Council of Justice reached out to Verkhovna Rada. So you provided us with this information. Please verbalize it again. What actions were taken by the Verkhovna Rada? How information was disseminated, provided, and what actually was the final result at the end of the day regarding this potential interference and regarding the implementation decision of the High Council of Justice? Yes, of course. The court controls implementation of all decisions of the High Council of Justice regarding interference into administration of justice, and it doesn't let it go without any guidance or follow-up monitoring. And this situation in 2021 was not an exemption. The National Police informed that they don't see any corpus delicti in actions of the Member of Parliament, and the Verkhovna Rada of Ukraine informed that the meeting was arranged with such a Member of Parliament, and he was told about the information that it's not allowed and unacceptable to interfere into administration of justice by judges. And this letter was sent to the court. And he provided us with a copy of that letter. Okay, then the next question. That your husband visited territory of the Russian Federation back in 2014, 2016. And it's confirmed by the data of crossing the border. So the visits took place in 2014. It was not one day, not several days, but it was during one day. So in the morning, he entered the territory of the Russian Federation, and then in the evening, he returned back to the territory of Ukraine. And in 2016, it was from 9th September to 25th September 2016. What was the connection? What was the reason for such trips? When it was only one day, frankly speaking, I don't know. I don't know anything about this one-day trip. And regarding that long periods, it was a flight to China because of working business issues. Unfortunately, I don't have right now my husband's traveling passport for that period of time, but I have somewhere a copy of it. So to confirm that indeed he went to the territory of the Russian Federation in order to take a flight to China. And where did he go? What was the nearest airport? So this was trip by car. I think it was Belgorod. I think that's the closest settlement located to Kharkiv. Thank you. Are there any other questions? Please, over to you. Hello, Madam Olena. I have only one question to you regarding declarations. Maybe I've got it wrong. Maybe you can explain. Yeah, indeed, there is so much property. Maybe I missed something. So I will explain what my question is about. So Declaration 2022, Section 3, line 25, you declare land plot 6702, and it was acquired in September 2021, but you have no information regarding this land plot in your declaration for 2021. So Do I miss it, or you have not declared it in your declaration for 2021? No, you didn't miss it. Indeed, the situation happened because of the following, and I provided a reply to it to the PCIA members, and I was sure that you also received this information and you're aware of it. No, my question is the following. We have this question also from the CSOs. So even if you have provided information in your written replies, we need to verbalize it right now to show it what has happened there. Maybe nothing has happened there. Specifically that you know about the station. Yeah, I fully agree with it. So it was my mistake. Indeed, I mentioned a LED plot. I failed to mention it in the declaration for 2021 because I didn't have any information regarding the fact of acquiring of this land plot. My husband provided me the purchase agreement for this land plot a bit later. I think it's because in 2022 it was a full mess in all cases, in my family, in our city of residence, in documents. So I don't think that it was his intentional step, and because all this information is mentioned in the Unified Register of Ownership Rights for a movable property. As soon as I received this contract from him, as purchase contract, and as soon as I realized that I provided not accurate information and following the NACP recommendations, I logged in my personal account in the website of the NACP and filled in additional information, provided explanation that this land plot was acquired back in 2021, and according to the NACP explanations, if the subject of declarations finds the mistake in their declarations by themselves, then ACP doesn't see any intention in making such mistake. But if there is no journalistic investigation regarding such properties, then relevant information that I have provided as a subject of declaration will be taken into consideration during the complete review of my declaration. Thank you. I just wanted to mention that in 2022 there was mess. Indeed. If everything was good, you should have submitted this declaration by 1st April 2022, this declaration. But because of the martial law, everything was postponed, and you submitted this declaration on 3rd of May 2023, not in 2022. Yeah, indeed. Sometimes situations happen that without any intention to hide any kind of information, I can get certain information from my husband a little bit later. So your reply is that your husband didn't provide this information in timely manner. Yes. So, and in your declaration for 2023 that you submitted on 31st January 2024, you mentioned this land plot. Yes, I mentioned it in the declaration, and afterwards in all other documents I also mentioned it. Thank you for your replies.
Alex, do you have any other questions? Duh Yaroslav. Madam Olena, I would like to ask a couple of questions about this event on the 23rd of December. As I've understood, at the beginning you mentioned that there were other judges, colleagues present there. Are these judges of your court? No, not judges of the Anti-Corruption Court. And having looked through the content of those publications at the website of the court, it doesn't mention anything that is something apart from your communication with the head of this institution happened. Tell me, please, when was this communication that you're talking about? That it was approximately in a month? At the end of January or before that? I did not say that I had some other communication a month after that. I was talking about the events of 2020, which the public learned as a result of the investigation in mid-January of 2021. So in mid-January, you talked to journalists and everyone who was interested in that. Yes. Can you please explain? Because I am looking at Transparency International, at other organizations, and they are all saying that no communication was organized. How can you explain that? At the YouTube channel of Transparency International Ukraine, there is a video recording of our conversation with Andriy, where I'm answering all the questions. So as far as I understand, it was after January 12, 14. Yes. A week after that, approximately. When the information space had publications with the assumptions and with complete lies, sometimes, of course, it was very painful for me to observe that. And I felt that I was obliged to provide an alternative view regarding this event, because I did not have any other way how to do that. No one submitted a disciplinary complaint so that I could properly prove my innocence regarding committal of a disciplinary offense. And then I did that, yes. Madam Olena, and my last question about that. In your staff, was this issue somehow discussed? Yes, we were discussing this. I provided explanation to my colleagues about the situation. On the same day, when the journalist investigation was published, in the messenger, colleagues asked a question, and I was saying, come to me, I will tell you as it happened. And on the same day, I told them everything that happened. Okay, thank you. Yes, please. Thank you for an opportunity to ask the question, Commission Member Melnik. Madam Olena, about the same story, but from a different perspective. So, some information has already been voiced. Purely temporarily, on December 23rd, there was an event where you saw the person with respect to whom there were some measures undertaken by the NABU, right? Yes. At that point, did you know that this person was a suspect under those proceedings that were investigated by the NABU? Based on the information that the National Anti-Corruption Bureau was publishing in the mass media, there were published some materials of the pretrial investigation that it was obvious that the person was a suspect. So you knew that, but from the mass media. Yes. I was back then. I was not an investigative judge, and that under that criminal proceeding, everything that I knew was what the public knew. I'm not asking about cases that are in the proceeding of the court. Never. Just purely for discussion of facts. The notice of suspicion was handed over on July 17 of 2020. So before the moment when you actually saw this person. So for 5 months, and the person already was a suspect. But apart from the notice of suspicion, there were other details. Were you aware about that, even from the mass media? As you've said, you were monitoring mass media and you found out about the status of the person from them. In particular, on 11th of August, this person was announced into search by the National Anti-Corruption Bureau because of failure to appear to investigative actions. And the NABU has addressed the High Anti-Corruption Court in order to ensure appearance of the person. But this information was published, and by the way, I took it from news publications. That's the source that is publicly available. All of this information is available there. Did you know that this person was under search warrant? No, I did not know about that. And accordingly, when you saw this person, you did not take any actions aimed at informing the National Anti-Corruption Bureau about the location of the person that was under search warrant because of their unawareness. I did not know that this person was under search warrant. I know some information, but not to this detail that you are mentioning. I'm not following the criminal proceedings in the jurisdiction of the Anti-Corruption Court, all of the criminal proceedings. I'm fully aware about all the details of those criminal proceedings where I'm taking part as a judge. Back then, I was not an investigative judge. And in that criminal proceeding, the pretrial investigation was ongoing. I'm never asking what is happening in their criminal proceedings. That's absolutely unacceptable. I did not know about that. Okay, thank you. Colleagues, do you have any other questions? No? Dear members of the PCIe, do you have I have a question, if possible. Madam Olena, do you remember the practical assignment, the case study about this declaration, the declaration for 2023, submitted in 2024? As of the moment of this action, there was one provision in effect, and then the provision changed, and the court applied either the old or the new provision. As far as I remember, you applied the previous sanction that was lower, and the disposition where the minimum amount of illegal declaration was increased. And you were applying untaxable minimum of citizens at the amount of 200, 600 hryvnias to the action that was committed in 2024. Accordingly, I have a question. Why didn't you use the substance minimum that was valid in 2024? Yes, that's indeed the sustainable legal position. I believe that calculation of inaccurate information should take place according to the substance minimum that was in effect during the reporting period, during that year for which the person is submitted the declaration. And yes, really, I broke down this provision into parts because the disposition also changed. No, I have no question about that part. Yes, yes. Yeah, I was asking only about the minimums. Yes, thank you. Thank you. Do we have any other questions? Dear PCA members, maybe you have some questions. Yes, Madam Mary.
Mary Butler has a question.
Thank you. I have a question about your ability to continue to own or the right to use the Kyiv property while you're on maternity leave. I'm not familiar with the law about housing benefits. Could you explain that to me?
Так, звичайно.
Yes, of course.
Моя родина не має
My family does not have housing in Kyiv.
Закон України передбачає,
The law of Ukraine sets out that in such case, I have the right to use the official housing. That is the housing bought by the anti-corruption court and granted to judges. I received an apartment, an official apartment for our residents. In 2021, we really bought, together with my husband, in the suburbs of Kyiv, a house with an area of 130 square meters. This house was without any repair works, so we had to do the repair works inside it. In 2022, in March, during the occupation of Kyiv region, our house was severely damaged as a result of a shelling with RAT systems, as we've managed to establish later on, based on the expertise. So that house was not suitable for repair works or for living. We repaired it on our own, and we completed repair works by the start of 2024, approximately. We did not plan to use this house as our place of permanent residence because it is located in the recreation area quite far from Kyiv, and we plan to use it as a house for weekends or for vacations. For example, even today, I was coming to the meeting of the commission, and it took me 2 hours 40 minutes to get from the house to the building of the HQCJ, so it's really far away. Especially given the weather conditions that we have today. So, according to the legislation, if I have housing in the region, in Kyiv region, I still retain the right to have official housing in the city of Kyiv. The law does not oblige me to give up official housing in this instance. Why don't we live in this apartment right now? Due to the shelling, right now the heating and the power supply infrastructure are damaged in the city. And right now there is no water supply at all in this apartment. And that's why we do not live there, because I have a small child who is 1 year old. That's firstly. Secondly, not far from that apartment, a military base is located. That's increased risk The building itself is produced from panels. So if someone hits it, it will just collapse like a card house. And the location of that multi-apartment building is such that all the time we have rockets and missiles and UAVs flying over the building. It's very unfortunate location of the multi-apartment building in this context. So right now it's impossible and scary to live there. And since I'm on maternity leave, we have decided to move completely into the house because it's possible to provide adequate temperature for the small child. And that's my explanation.
Thank you.
But when I will start working again, then of course I will have to move back to Kyiv because it's a luxury to spend 2 hours to get to work and back home.
Thank you.
Yes. Colleagues? No? No further question, Mr. Chairman.
Добре, дякую.
Okay, thank you. All the questions have been asked. Madam Olena, now you have an opportunity to address commission members and PCA members, and maybe you would like to provide some additional explanations. But please be concise if possible. Yes, of course. I will not take too much of your time. I would like to point out that I have done everything possible to provide the information with respect to which you sent questions in the request of the PCE and the HQCJ. Those questions to which I provided answers that complies with the law, but maybe does not correspond to expectations of the PCA in particular. They envision provision of assumptions by me. And in my understanding, it's much worse rather than just saying honest information that I really do not have information about the value of these vehicles. The law that was in effect as of the moment of filling in the declaration in 2015, 2016, 2017, 2018 did not require that from me. And that's why I did not declare that information. And to inform information that I'm not sure about and my husband is not sure about, just for the sake of providing at least some answer, in my opinion, that was unacceptable. I've tried to be sincere, as open as possible, and to provide all the accurate information for objective consideration of the issue regarding the possibility to appoint me to the position of the judge of the appellate chamber of the High Anti-Corruption Court. Thank you. Thank you for your participation. So I'm announcing the interview over. Thank you. Goodbye. Colleagues, we've exhausted items of the agenda for today. Thank you for work. Dear members of the PCAE, thank you for your work. And dear members of the Public Council of International Experts, thank you for your work. And dear members of the High Qualification Commission of Judges, thank you for your work.